Good evening, you're with ET now. This is a brand new edition of the India Development Debate, the only news debate on national television that puts the spotlight on development issues. I'm Sandeep Gurumurthy, joining you live from our news center here in Mumbai. And straight to the big debate tonight. Cambridge Analytica's and Facebook's beware, stealing personal data using their social media platforms could land them in a soup. Justice B. Srikrishna, who was entrusted with the job to create a legal framework for data protection, today submitted a comprehensive list of suggestions to the government calling for steep penalties for data breaches. Interestingly, the report also raises questions over the centre's aim to make Aadhaar mandatory for availing government subsidies. Speaking to ET now, soon after the report was tabled and released, Aadhaar architect Nandan Nilekani admitted that the panel's suggestions will have a bearing on the Supreme Court's verdict in the Aadhaar versus privacy case. The report also casts shadow over the RBI directive on data localization, providing the way for data hosting on foreign shores. The Srikrishna panel's suggestions on data privacy and the impact on Aadhaar and KYC norms of financial sector regulators like SEBI and the RBI, and beyond, the impact on the common citizen. That's the topic of discussion tonight on the India Development Debate. But before we take it across to an eminent panel that's joining us on the show this evening, let's get you a slice of the exclusive interaction that we had with Aadhaar architect Nandan Nilekani, who spoke exclusively to ET now on the draft framework, spoke to my colleague Chandra Shrikant. Nandan Nilekani says it's logical for Aadhaar to come under the purview of the data protection law. Listen into that exclusive conversation with ET Now's Chandra Shrikant.
I think they have given a very balanced opinion on Aadhaar. On the one point, on the one side, they have said that it requires the Act requirements, amendments to ensure the autonomy of the UIDAI. At the same time, they believe that UIDAI or the Aadhaar, UIDAI need to have the powers to do enforcement. So, it's sort of simultaneously addressing that. But, I think it's also the fact that the UIDAI will now come under the larger framework of the data privacy law and the data protection authority. And it will also be subject to the same law.
Sir, in fact, as you said, they've taken, they've taken a balanced view. So, in the two set of amendments with respect to Aadhaar Act, the first has to do with bolstering the right of privacy of individuals. So, yes, a critical obligation on all data fiduciaries. And second, you did say that they have said amendments are required to ensure the autonomy of the UIDAI. Now, in the last line, they said, Aadhaar as a method of identification, the need of the hour is a regulatory framework for the operation of Aadhaar. So are they saying that, UIDAI alone is not enough because it's just a platform? There needs to be a regulator above the UIDAI because you cannot have the same organization that's also making the rules and that's also regulating itself. Would this be the right way to interpret what Justice Srikrishna has said?
The way I see it is that on the one hand, they are saying the Aadhaar Act should be, the UIDAI should be, should be autonomous and it should be able to enforce. For example, if there are requirements that Aadhaar number is not displayed, then and if somebody displays that, then UIDAI needs to be able to enforce that kind of errant thing. At the same time, I think it also says that UIDAI itself will come under the DPA, the Data Processing Authority. So to that extent, I think it also creates a situation where if the UIDAI, if somebody believes the UIDAI is not, doing what it should, then they can appeal to the DPA. So I think it does both.
You have been someone who's been pushing for a data protection law right from 2009. You raised this with Prime Minister Manmohan Singh and subsequently with PM Modi. Are you confident that, this will go through?
Well, they have done
okay, May of 2010, you clearly will know the dates better.
No, I think May 2010 was when I wrote to the Prime Minister, Dr. Manmohan Singh, about the law. So it's about it's more than 8 years now. But I think the point is that I think this is a landmark event because you have a great report which talks about protecting privacy at the same time empowering Indians. So I think that's a very strong thing, and clearly saying that the Indian model is different from the European or the Chinese or the US model. And second, it also has given a draft law. Now, next thing, I think the next big event we have to wait for is the actual Aadhaar judgment from the Supreme Court. And it's entirely possible that that judgment may take notice of of this report as well as the draft law, and may make some comments that perhaps the government should look at passing a law within a certain time frame. So I think this is there are two steps. The next step is the Aadhaar judgment, and then we have to see whether on top of that there will be some recommendation by the Supreme Court that the law should be passed.
Right, it can take some time. Some people are saying, a few months to a year. But what will this mean as far as that Aadhaar judgment in the Supreme Court is concerned? Are you, more optimistic? Are you sort of cautious at this point? Are you cautiously optimistic? What does today's data protection framework mean for the Aadhaar judgment, which is perhaps a few weeks away?
No, I think this, the very thorough job done by the Srikrishna committee in defining the privacy, I think will help and will actually contribute to the court giving a balanced judgment on Aadhaar itself and taking into account the recommendations of this committee.
Before I let you go, sir, this is not the first time we've had recommendations on privacy. The Justice A.P. Shah Committee too had laid out principles of privacy a few years back. Are you more hopeful that this time at least, there is more commitment to ensure that this doesn't just remain a report or a framework, but it will indeed become law, be it 3 months, 6 months, 1 year, depending on, when the Parliament decides to pass the law. But are you more hopeful this time around?
Well, to give you a timeline, in 2010 May, I wrote to the Prime Minister. Then the DOPT appointed a group and came out with a draft data privacy law. Then the Justice A.P. Shah Committee was set up to came out with privacy principles. And then, all that happened. So, many things have happened in the last 8 years. But I think now it is the end game because the Aadhaar judgment will come out. And I think between the Aadhaar judgment and the Srikrishna committee report as well as the draft law, I think it lays the foundation for a law to happen. And as I said, it's entirely possible that getting a law to be passed may be a requirement of the judgment.
And then Nilakari, an important, influential voice that one must hear on a day like today. But now we've got a panel that's going to debate threadbare the recommendations and the scope for data privacy in this country, the implications on the Aadhaar framework as well. Pleasure to welcome on board Nikhil Pava, founder, editor and publisher of MediaNama.com, Saket Modi, founder of Lucidus Tech, Vineet Goenka, ex-national co-convener, IT cell of the BJP, and Sanjay Jha, spokesperson of the Congress party. I hope we keep this a non-political discussion to the extent possible. Nikhil, I'm going to start with you. Your tweet earlier this evening said it's a weak bill. Why would you say that? I mean, they've gone into some detail in defining consent, they've set out right to be forgotten, and also a penalty structure that has financial and criminal parts to it. So why would you still call it a weak bill, Nikhil? So why would you still?
Well, I think the problem is that they don't give, the bill doesn't give users complete control over their data. There is no right to erasure of data in particular. So, if let's say Facebook has my entire profile with thousands of data sets, firstly, this bill does not allow me access to that entire profile of what data they've collected about me. It only allows me to get a summary of that data, so there's lack of transparency. Secondly, if I want to get that data deleted, I can't. There is data portability, but there is no mention of the fact that once you port your data, the company can't retain it. There is the right to be forgotten, which means that they can't disclose the data publicly, but that doesn't mean that they can't collect it and store it. So effectively, it's not giving me complete control over my data. And I think that's where this particular committee has failed us in particular. There is also no restriction on mass surveillance.
Nikhil, allow me to interrupt you there. Let's pick one point at a time. What you're saying,
one of the things.
Nikhil, let's pick one point at a time. Your fundamental premise is that this does not give complete control of the data to the owner of the data. So in that sense, it's not good from a citizen's point of view. If I get you wrong, simplistically put, that's what you're saying. Saket, do you agree with Nikhil? Do you believe that it hasn't gone to enough depths to ensure that the user of the data has control over it?
I still haven't obviously been able to get the chance to go through it in a detailed way because it's still, a couple of hours since this has come out.
200-page report.
From what the report. But the fact is, I from what I see, it looks like a very, very strong, strong document, which, as you very rightly mentioned, it's not just about financial implications, it's actually criminal implications to the tune of what you would generally charge somebody with a rape case or a murder case, because it's non-bailable offense is what we are talking about out here. So my initial reading of the report is it's extremely strong to the point of, the right of being forgotten. I see that they have mentioned that. The specifics of what Nikhil is mentioning, I will have to relook at that and then come back to him on the same.
Okay, fine, fair enough. Let's take it to the politicians then on the show this evening, and let me take it first to you, Vineet Goenka. The draft bill is here a year after the committee was set up. Where does it go from here? How long before it becomes law?
First, let me congratulate Justice Srikrishna and his team, because I have never seen a piece of law which has come like this. It's a draft bill and which compasses of all the queries which the citizens had. Number two, not only the draft provisions of the draft bill, but also the procedure which he followed, making a white paper, throwing it to the public, let the stakeholders revert, then taking the points of the stakeholders and then coming out with this draft procedure. I think it is a fantastic work done by his team, and so we should applaud him. And as rightly said by Ravi Shankar Prasad ji, that the procedure of the cabinet will be followed. After that, it will be tabled on the floor of the house. So there is a procedure. It will go to the cabinet will understand it. It will be seen with Toto, and then there will be discussion on that, and probably all the procedures, maybe tabling in front of the various committees which is there, and then finally it comes to the house. So I don't know what time it will take, but this is a comprehensive law. This is going to
you want to address the okay, Vineet, if I may interrupt you, I have a quick follow-up for you only. Do you want to address the concerns raised by Nikhil Pawar there at the start of the show, saying that the draft does not do enough to address the concerns of the citizen and the fact that he still doesn't have complete control over the data? You want to address that concern?
I don't know where this fear is coming in the mind of Nikhil ji, but I think this is the first time when they have defined what is data, how does it collect, what is the definition of that, what is the role of the judiciary, what is the role of the fiduciary, what is the role of the individual data owner, data principal. I think this is completely a full cycle bill which has to be uploaded, and there is no flaw as such. In fact, we have been demanding one thing which many liberals probably or other parties were not talking about, is data localization. Even that has been discussed here. The data localization, data sovereignty part has been discussed here. They have discussed about the authority, also the penalty. See, the penalty, one of the penalties which I read is percentage of the worldwide turnover of a company. So now that makes it punitive on all the companies to follow this in toto. So probably this is a complete bill. I don't know where this fear has come in the mind of Nikhil Pawar. Maybe he has to reread the entire draft bill once. I will request him to read it, because most of the people, whichever I have talked after this paper has come out, seem to be very happy. I have talked to CEOs of various companies, maybe companies which are more than $1 billion, and each of them is happy in this.
Okay, Nikhil, I'll let you respond, but first let me get a word in from Sanjay Jha. Sanjay, how are you reading this? And the Congress party, I'm sure you heard that interview with Nandan Nilekani, whom to be fair is not a Congress person or a BJP person anymore, and independent authority on this matter. The Congress party had set up a similar committee under AP Shah, but it never became law. Can we hope for a different outcome this time around? Will you support the BJP to pass this crucial law?
Well, let me tell you one thing, Sandeep. First and foremost, what we got to recognize is that in India, and people who have seen Aadhaar's leakages over the last 4 years will realize as to how data privacy has been breached in broad daylight. I mean, you know about that report where people were buying Aadhaar data of millions of people and putting it out in the public domain and selling it to telemarketers. I think that scam, was scary. The issue here is fundamental. This is a recommendation, it's a draft bill. And ultimately, I think every feedback that the bill gets from stakeholders, from the public in general, it ought to be very transparently discussed. Now, I have two questions basically. I have read the key highlights of the bill. Obviously, nobody has had the time to go through it, in entirety. But there is one clause that I think will require greater clarity, which talks about the government not requiring your consent in certain situations. I think they need to be defined very clearly, because that can be subject to extremely insane abuse by a totalitarian government. So you need to make sure that, end of day, an individual who feels his right to privacy has been violated can go to the courts and win the case even if he's taking on the government, doesn't have to be just Facebook. I do feel that we are pretty much late in the day. End of day, don't forget that the Facebook has had a whole law, which the European Union passed remarkably in great cohesion at fantastic speed. So where there's a will, there's a way. And I think bottom line is how transparent are we in terms of involving the citizens and hearing their problems. This is definitely a start, but I can tell you the government will have to be extremely flexible and they must listen to all points of view, including the opposition. Because I felt extremely concerned when the government actually went to the Supreme Court on the right to privacy issue and went and argued that right to privacy is not a fundamental right. That was a very disturbing statement from the government. So I think we need to be very, shall we say, circumspect and cautious even at this stage.
Okay, cautiously optimistic if I'm reading you right, and that's good to see, good to hear cautious optimism. Vinit Goenka, I'll come to you, but I want to address some concrete issues. Nikhil, back to you. Are you satisfied with the amendments suggested on Aadhaar? It's called for a regulatory framework and also steps to bolster data protection. Is that enough? You've been raising a lot of concerns over Aadhaar and you've been sort of a crusader of sorts. The steps on Aadhaar, do they satisfy you?
What are the specific steps on Aadhaar in this bill? There's just one amendment in the bill. I'm talking about the bill and not the report. There's a difference between what's been recommended in the bill and what's in the report, right? And so as such, as far as I can see, there's nothing significant that they're doing about Aadhaar. In fact, what the bill allows is, a non-requirement, as far as my reading goes, a non-requirement of consent for, functions of the government. That's a very wide phrase. And very vague phrase to have, which allows complete free run to the government to collect and process data without any oversight mechanism here. So I'm not very happy with this bill the way it's come out. I would urge all opposition parties to push for amendments and not allow it to pass. There needs to be another public consultation, and preferably without the involvement of people linked to Aadhaar on the committee, more civil society participation. This has been a remarkably opaque committee. They may have done consultations, but the submissions have not been made public by them. They've been refused under RTI. The consultation should have been on the draft bill and not the initial report. So there needs to be another round of consultations here. This committee's failed. It's completely failed us, to be honest.
Okay, Nikhil says it's completely failed. Vinit Goenka, coming to you, your response specifically on the issue of Aadhaar, which is of course the burning issue, isn't it?
So I'll take all the three queries which has been raised by Sanjay ji, Nikhil ji and yourself. One, there was a draft white paper been put in the public domain, and each of us, in fact, I had reacted to that, and one of the events which I had organized, Nikhil ji himself was there to discuss, and it was discussed with press, this was discussed with people of the society, there were companies which represented, there were association which represented, and everybody gave their feedback, their concerns, their views. I gave my personal concern, that is about data localization sovereignty, that everything should be localized, and I'm happy it has been accepted. So each and every individual was given a right. My own suggestion has been accepted. So I have that kind of pleasure suggesting that. So this blame or this kind of pointers are incorrect because it was in public domain when the white paper was there. Number two, right now also it's a draft bill. When there is a draft bill, if there is a genuine concern, I think there can be a suggestion being sent to both the parties. It can be opposition, it can be the standing committee, it can be to the law minister. Nobody stops Nikhil ji or anybody else who has some kind of opinion. Number three, as the minister comes on record, he says full procedure will be followed. Full procedure means it will not come through an ordinance. It will come through discussion and deliberation. So if there is any kind of iota of doubt in somebody's mind and anybody has a suggestion which he thinks will strengthen this bill, should come out and write a paper to them. I think it will be considered. Now on the part of which one Mr. Nikhil ji made, personal data can be processed for parliamentary, state and G2C services, public interest where it is felt necessary. Now when an independent state works, it requires certain data to do it, and there they have defined what is the time it can be used when it is meant by non-taking this consent. So that has been clearly defined in the draft bill, and I think it is appropriate. I have not seen this kind of draft bill anywhere. Whatever 6-7 countries law I have read on this, or GDPR which I have read on this, I think this is a larger one. This could be basically a mother law and across the globe if you see. So entire thing has been taken. Now coming to the third point, the Aadhaar part. Aadhaar itself is a very strong database. It has been considered. I don't know why people are raising noise about it. It's a third party which has leaked. Now with this bill, the leaks will be identified, not only identified, but there are penalties, and the penalties come to criminal preview. So this will help if there is, in case of any doubt whether the Aadhaar will have any kind of leakages. And we are also waiting for the judgment of Supreme Court. Which
okay, I take that point. Let's get quick rebuttals to what you are saying.
Once
first to you, Sanjay Jha. Okay, allow me to interrupt you, Vineet Goenka. Quick rebuttal from you, Sanjay Jha. On Aadhaar, right, there's accountability of UIDAI. There are strict penal provisions for any form of data leaks that you pointed out, which has been an issue of concern for citizens at large. So there is a legal framework, and I'll get Nikhil to react after you. But Sanjay, your response on Aadhaar?
Well, I would, keep my fingers crossed and hope that the citizens of our country, most of them who are struggling day in and night out for their bread and butter, and sometimes are not aware of the dangers of right to privacy being flouted, will now be protected. I think the big concern remains that because the UIDAI structure has been extremely, shall we say, poor, it's been weak, I mean very frangible foundations, it is still subject to significant hacking. And what we have found so far, that even under the current provisions of the IPC, when charges could have been leveled, investigation could have happened by the current government under preventive laws, they were not done. And you know about the Jharkhand government leaking the details of lakhs of people, including Manrega beneficiaries. So you have a situation today where it's all about political intent finally. I think we can get a law like, for example, we are talking about the lynching law in India, but ultimately it's going to be about how do you execute the law. Therefore, I think it's critical that the provision that I mentioned, and I think Nikhil seconded that, where it seems to give a wide, very nebulous, it's a very nebulous statement, it's very amorphous if you read it. It actually gives the government a blanket carte blanche to do whatever it wants in certain circumstances that I don't think are clearly defined. I can understand if you say war or major national security, but it also mentions certain other things there that are not terribly convincing. And it talks about reasonable use.
Okay,
I think these are things that will obviously be debated,
sure.
And I don't think they can survive an amendment.
I agree, and I take that point. And to be fair, Vineet is saying that let's debate these issues. It's going to follow the due process. You and I can write to the government, and of course there'll be a heated debate in the parliament where your party can push through some of these amendments, and hopefully we'll get the best outcome. But Nikhil, quick reaction to you, and then I need to go to Saket on data localization. Nikhil.
Just on due process, it required for the committee to make submissions public. It never did. Minutes of the meeting of the committee have not been available under RTI beyond an initial response. They've refused it thereafter. So I don't think due process was followed over here. I want to comment on the data localization piece. I think it's important to remember that mirroring of all global data is being allowed is being enforced in India, which is not feasible and practical. Basically, you expect a small startup in Mexico that is servicing Indian users to start mirroring its data in India across billions of apps and sites. I don't think that's going to happen. And secondly, I'm glad that cross-border transfer of data is being allowed, which is something which Mr. Goenka had actually been opposing. So I don't think all of his recommendations have been accepted here, which is a good thing.
Which is a good thing, right? I mean, the fact that that it's a democratic process and the committee has applied its own sort of judgment is good. But Saket, on the issue of data localization, that's an important point. The reading on data storage is somewhat confusing, and I tend to agree with Nikhil there. While they've said some data sets can be stored outside India, they also say the data fiduciary must save a copy in India. Isn't that going to have a huge impact, not just on Facebook or Google, but even on small startups that use an AWS or an Azure, because it's cost effective? In fact, I am told that one of the members of the committee has submitted a dissent note on this particular issue, which is being made public as well. So one of the members of the Justice Srikrishna committee has also submitted a dissent note on this issue. Saket, your reaction to this point?
No, I agree with you out there, Sandeep, when you say that obviously if a small startup is asked to make sure that the AWS server instance is storing the data in India, that becomes a challenge. But let's look at it the other way around. If you look at it as this becoming a law, if AWS is to survive in India, if Azure is to survive in India, the way they give an option to an American startup that, you can decide which will be the instance of the cloud that your data would be stored on. I mean, they will have options with Indian data centers and Indian instances also. So, that's like the chicken and egg thing, right? Till the time you mandate the global giants, because they provide software as a service or infrastructure as a service, till the time you mandate them, they would still want to keep their costs low to whatever extent possible, and say, look at India as probably, a future story than a today's story. But the moment the law comes in, they would be forced to do it because, or whoever does it will really walk away with a lot of business. So, of course, none of these companies will want that. So I think that, yes, there is ambiguity there, but in the long term, data has to be, governed and stored in the judiciary of the Indian territory.
Vineet Goenka, I want you to respond to that, and I'm adding another question, which is a challenge that many people foresee on execution. Isn't it going to be a nightmare to execute? The committee has identified overlaps with at least 50 statutes and regulations. How will you go about doing this?
Well, on the data localization part and the sovereignty part, because that's been my subject for many years, and I mean, what I've been in individual capacity advocating is complete sovereignty of the data, and the data should not go outside the precinct of the country. But here at least one part has been said, the data will be kept here. We have to remind everybody, maybe Nikhil Pawar, people like him who feel that India does not have a technological support here. We are 1/6 of the human beings, 1/4 of the consumers on netizen. So here, once we take a step, our foreign partners have to put their shops here or leave this market. So we have a dictatorial terms which can be put down, because that will help us. Now these terms may look little authoritative, little dictatorial, but then we have this market, and I think in the fair play, the market can determine where the data will be. So here we should say that let Indian homegrown data centers should come up, indigenous data centers should come up, and if there are foreign partners, they want to put their shop here, they want to put their data centers here, they are most welcome. But this will give us an opportunity, create employment, also secure the data within the precinct of this country. Now here, third part is, what about the data's discussion? There are approach, they have the entire draft bill has discussed about appellate authority, and probably that authority will also help us to understand and interpret the law. Now this is like what rightly Justice B.N. Srikrishna said. This is when you put in a new shoe, there will be some kind of pinches, there may be times it will adjust, but over the period, the shoe becomes part of your regular wear. So we'll have to wait and watch until the final bill comes out.
That point, Sanjay and Nikhil again both want to respond to what you said. Sanjay, I come to you first, and then I'm coming to you, Nikhil. Sanjay.
Sandeep, my first hope will be that the government does not introduce the bill as a money bill and pass it in the Lok Sabha where they got a majority without hearing what the Raj Sabha has to say. I think that is my first genuine fear. Okay. My second point will be that you have to go by the experience of the Right to Information Act. Now, when it was started, I mean, the worldwide there was appreciation that India had the most transparent anti-graft act, which would take on corruption, especially in the bureaucracy and the political system. Now, let me tell you, that act has been diluted to such an extent today that if you want to even know whether the certificate of Narendra Modi is genuine or not, they refuse to give it to you. Now, these are the worries, which is why I'm going to come to the point that, it's not going to be enough to pass the act tomorrow, whatever happens. It's going to be the responsibility of the ruling government, whichever party, to ensure that you stick to the principle of fundamental rights of a citizen and really treat that as sacrosanct. Okay. I think until and unless as a country we are wedded to the right to privacy, all this will come to naught. And I think it boils down to the intention of a political party.
Okay, Nikhil, Sanjay, there's another point that I must mention which the Congress would want to raise at some level, which is on the amendments that is talking or in effect, which could weaken the RTI. And we'll talk about that. I hope we have time to touch on that as well. But Nikhil, quick response to what Vineet Goenka was saying, and then I need to get closing comments.
Sandeep, I've got 3 additional points to make, so I'll just, because I don't think that's been discussed yet. Point number 1 is that, data portability can be prevented under this law if it is not technically feasible. Who decides whether the data portability is technically feasible or not in this case is up in the air. Number 2, there's a very odd suggestion or an odd clause in the law which says that the liability of removal of consent will lie with the data subject. So if I've given my consent to a company to collect my data, if I remove that consent, I will have the liability of removal of that consent. Why is this even there? Lastly, I think this is very worrying. If there is a data breach, the data controller doesn't mandatorily have to inform the user that the data has been breached. It's up to the data protection authority to ask that for the user to be informed. So if a data protection authority doesn't want users to know that their data is being breached, users will never find out and they'll be compromised forever. If your password is leaked and the company doesn't want to inform you, or the data protection authority decides not to let you know, you're gone. Why is this clause even there?
That's a fair point you're raising. Vineet Goenka, I want you to respond quickly to those points, and then I'm going to get Saket to comment on another broader issue. Vineet.
I would request Nikhil to reread the entire draft bill. These have been addressed. I don't know why he's raising this. And in case he feels it has not been addressed offline, or whenever he wants me to explain it to you, I can do that. The bill takes care of that. It's been defined there. So there is no question of ambiguity. I think this is very nicely done. Now, one point where Sanjay Jhaji pointed about Narendra Modi ji's certificate, let me just remind him. Here we have come out with laws which are very strong. Money laws was interest only when there was a black money was part of that. Here the minister has come on record to say that there will be due process of the cabinet will be followed, the parliament will be followed. So there is no worry about what type of bill this is. Thirdly, Sanjay Jhaji, just for your this thing, we follow every process which is laid down in the constitution. When we honor Supreme Court's judgments, we also take cognizance of Supreme Court's judgments. This is not Rajiv Gandhi's government where the Supreme Court judgment is set aside by forming a law like Sahabanu's law. So be assured we will take care of the Indian citizens and the law very nicely.
Okay, Vineet, I take that point. Saket, a bigger picture question that I'm sure every citizen of this country watching the show is wondering is, does this bill carry enough power to preempt another Cambridge Analytica, or at least penalize a CA heavily when there is a breach next time?
You know what this is, according to me, it is not just penalizing a potential Cambridge Analytica with 4% of the global turnover, which a GDPR does, but something much more than that, and that is the non-bailable criminal offense that comes in along with the financial implications. So basically what this implies is there is by no means that a company can mess around, play around with the data. I think the way they have defined what is really, personal data that belongs to the person, how does that, constitutionally get stored, where does it get stored, and who has the authority to access it, and of course to delete it when they want, is very, very articulate. And I can tell you this is one of the most important days in the history of the digital India journey, where I think it's a very, very reassuring thing that has come in from the government side.
Fair point. One last concern I want to flag off, and I'm coming to you, Nikhil, after that, which is to you, Sanjay. Are you particularly concerned that this could weaken the RTI framework? Because the committee talks about amending Section 8(1)J, which deals with personal information of an official. Is this going to be a trade-off between transparency and privacy on the other hand?
Sandeep, that is going to be, I believe, the seminal issue that we need to confront. We have found that this government of Mr. Modi is extremely opaque. I mean, RTI has been diluted completely. You know that the recent amendments they were making, until we protested, until Mr. Rahul Gandhi protested, actually the government was going ahead with that. So what is the real challenge India has? You have a government that clearly does not believe, and now of course it has to adhere to what the Supreme Court has said, but it did not principally believe that the right to privacy was your fundamental right. Now that was its initial thought process. Now it will obviously do everything in its capability to try and ensure that that objective of theirs is met. So they could subvert it, and if RTI is used through the DPA to not disclose information that is something that the consumer has a right to know, then yes, transparency will take a huge hard knock. It already is getting a lethal blowout, I can tell you that. And today it's worrying, and I'll give you one more example. You remember the much hullabaloo over the Lokpal Act? It was passed in 2013. It's not yet implemented by Narendra Modi's government, despite the Supreme Court literally firing it. What does it tell you?
Point, but that's beyond the scope of this
Please
debate,
remember,
Sanjay.
you can make the greatest
Okay.
of laws in the world.
Fair enough,
but you
fair
need
enough. I take that
political
point, but that's
governance
beyond the
for
scope of this
ultimately
debate. We will do a debate on corruption. I'm sure you can make this point then. Nikhil, I'm coming to you. Nandan Nilekani, as you may heard part of that interview, I know you disagree with him on most things related to data privacy and Aadhaar, but he said, as he summed up his assessment, he said that this strikes a balance between, on the one hand, the free market US regulation and the stringent EU norms. So on the one hand, you have US, which is very sort of lax, and then you have EU, which is very stringent. So he believes this strikes some sort of a balance. Do you disagree or agree?
Well, the way I see it is that the EU GDPR is at this point in time the strongest privacy law out there, and I don't think we need to have a balance there. We need to have a strong privacy law. This is about citizens' rights over their own data. It's about protecting us because our data is being weaponized against us. And let's face it, Nandan Nilekani is a part of that entire system that is collecting vast amounts of data. He's enabled that system through Aadhaar, that is going to be weaponized against us by the state. You have, in Andhra, you have state profiling citizens, creating 360-degree profiles of citizens. So I wouldn't trust anything that Mr. Nilekani says about this bill. If he's happy with this bill, then I think there's a problem for the citizens and their rights.
You heard Nandan Nilekani, and then now you're hearing one of his big critics sort of criticize his assessment of the bill. We leave it to the viewers really to make up their mind on what they want to go with. Okay, Vineet, very quick last word to you. I'm completely running out of time. Very quick, 30 seconds.
I will just request people like Nikhil Pavaji to be a little responsible when they make statements, because this bill is in total completely very good, and I don't know where his fear comes out. When he runs a company, he has to own the responsibilities of that. They cannot run away from there. Now, I don't know what this fear comes up. This bill, I think, is a very good piece of legislation which has been shown as a draft bill, and then there is a scope of discussion by all the stakeholders. So, I would like to thank Justice Srikrishna and his team to do this a good job.
Cannot deny is this bill is probably a good beginning. It will sort of rekindle the dialogue on data privacy. We will of course have the Supreme Court judgment on Aadhaar coming through sooner than later, and then hopefully our lawmakers will debate, will fine tune this bill, this draft bill, and arrive at a data privacy framework that protects our privacy rights and yet does not compromise on transparency. Thank you gentlemen for joining us with your perspective. Sanjay Jha, Saket Modi, Nikhil Pava and Vineet Goenka. We'll slip into a short break. On the other side, a legal voice, a legal opinion you don't want to miss. Harish Salvi will be speaking to us exclusively, live and exclusive from London, on the other side of this break with his assessment of this data privacy framework. We're back in a moment for that conversation with Harish Salvi. Back with the India development debate on ET now, and joining us is a very special guest, live and exclusive from London, Harish Salvi. Mr. Salvi, really appreciate you taking the time and joining us with your perspective on this. It's an over 200-page report, and we've struggled to go through all the pages, so I can imagine someone as busy as you would have not had the time to go through it. But based on what you've seen so far, read so far and heard so far, would you say that this is a strong data protection bill and a good start for India?
Honestly, I've seen about the first, skim through the first 20 pages of the report. And the whole point which this report captures, to me as a lawyer, it changes the paradigm of the relationship between the service providers and the customers. What we had heard in the Supreme Court when we brought the matter up was a strong argument by Mr. Sibal that it's the relationship, for example, between WhatsApp and a customer is a purely private relationship. Don't want it, don't take it. And somebody, I think, who's appearing, I think, for Facebook, used the same arrogant tone. Don't want it, don't take it. I think this data protection law, which brings in constitutional precepts, brings in the law to the constitutional right to privacy, raises this relationship to what we as lawyers call the fiduciary level. So it's no longer contractual, it is a fiduciary relationship in which the service provider has a great duty of care And once you change this paradigm, then everything falls in place when it comes to data protection. Be it the government, be it a private person, when you receive information on promise that you will keep it sacred, you will keep it private, and secondly, merely because you are providing a service, can you impose terms and conditions inconsistent with the constitutional right to privacy? These were the issues, and I think this report squarely answers them. It says you have to cast a strong duty of care on those who want to enter into this space and provide service, be it the government, be it private agencies.
Framework, Mr. Salvi, goes into some detail on consent, stating it should be free, informed, specific and capable of being withdrawn. While that is positive, do you think the framework should have had more on the limits of consent, especially surveillance mechanisms by the government? And that's a concern that some people are pointing out.
See, you must also understand governments operate at two levels. Surveillance by the government as a part of law enforcement, as a part of security state, does not require consent of a citizen. It's a part of what we, on a global level, what we call the police powers of a state. Every state has not the power, but the duty to protect all citizens. And if in achieving that duty, it has to, in exercising its police powers, it has to take certain steps such as tapping phones or looking into messages. Well, that's qualitatively something which is different and which has to be dealt with separately. So I somehow feel many times this debate blurs these lines. We are dealing with an area which falls outside the area of legitimate surveillance. What is legitimate surveillance? And in India, there is a huge gap where surveillance rules are thrown to the winds. And we unfortunately have become a society which is like the lynch mob. When the Radia tapes brought out the complete breach of all norms of how surveillance is to be exercised, we looked the other way because we thought the stuff which came out through the Radia tape was so juicy, so salacious, it needed to be discussed. Of course, the investigation brought out a big zero at the end. But everybody had a good time gossiping about who said who, what about whom. So that is one area which is outside, I suppose, the remit of this report. How should police powers be exercised and what should be the checks and balances, and more importantly, what should be the accountability of those who break the rules on which surveillance is to be exercised. This deals, I think, this data protection law is more about service providers and the users of those services, the social media or other communication service, or people who, for various reasons, share personal data.
The other aspect, Mr. Salve, was on data localization. While it has given a nuanced approach on how some data sets should be stored only in India and others abroad, the devil perhaps lies in the detail here, because they've said that there should be a copy of every data set stored in India too, even when it's abroad. Now, a lot of people are wondering, how are companies big and small going to execute this? Even the GDPR in the UK doesn't have such a stringent provision.
See, the object behind the report is perfectly laudable. What we have seen in recent times about the revelations of how Facebook data was treated, with what absolute disdain for people's privacy these big, large companies have been operating, it does give rise to a apprehension that if data is not kept within the country, tomorrow you need data, you turn around and you ask these people for verification of the data, they say, sorry, it's not there, and you have no way of enforcing your laws. Because believe me, today, even the principles of what we call private international law, that means which rule of law, which principles of law apply to which activity and which entity, have not yet caught up with the virtual world. I mean, we used to believe those days that the law, if an asset is concerned, the law where the asset is situate will apply. Where a publication is concerned, the law of the place of publication will apply. Now you put a blog on the internet, it's published all over the world. Now, which country was going to govern that? So, in order to give some sort of a what is called a jurisdictional hook to how you deal with data, I suppose these kind of measures are necessary. Can they be achieved? I'm just about superficially familiar with the working of computers. I know as much as I need to know about using them for my work. Beyond that, I have no idea.
I take that point. Mr. Salvi, what do you make of the amendment suggested on Aadhaar? The report has acknowledged the wide scope of Aadhaar and has called for a regulatory framework. Should we interpret this as some sort of a division of power between the UIDAI and a regulator above the UIDAI who will administer breaches, leaks, etc., which has been a concern of a lot of citizens?
See, today there is one of the concerns which has been expressed. I mean, if I may say so on a somewhat lighter note, I was delighted in the first 10, 20 pages of the report to see references to jurists like Ronald Dworkin, like Vaz. These are the liberal thought jurists in constitutional law, and I'm a great fan of this kind of thinking. So, anything which is government-centric is looked at with some degree of concern. So if the report suggests that Aadhaar also should be subject to some regulation, because ultimately Aadhaar is Government of India, I think it is something we should look at carefully. Don't look at it as a turf war. Think of improving what we have rather than considering this, and I'm sure some people will jump to the conclusion saying, yes, see, our point is made. We are vindicated when we criticize Aadhaar. Nothing of the sort. These ideas evolve, principles of protection evolve, principles of constitutionality evolve. So this is not a criticism, it's an idea which one should consider. And I think to start by discussing it as a sort of a turf divide as to will the UIDAI come under somebody else, will somebody else have the right to call the shots? Don't make it so completely divisive. Don't reduce the discussion to so completely adversarial.
Okay, I take that point, Mr. Salvi, but here's another question, and I think you are probably best equipped to answer this, which is how is all of this going to play out practically? You know, we have a data processing authority now, or we will have, which will regulate data, but we also have sectoral regulators. So who will set limits on where jurisdiction begins and where it ends?
I think there will be overlaps and the Supreme Court will draw the lines. I'll give you an example. Recently, I argued a case, and the question was whether if one telecom company makes complaints against another telecom company saying it was denying it interconnect, it's in public domain, so everybody knows about it. Who is the last authority? Is it the Telegraph Regulatory Authority of India, or is it the Competition Commission of India? Is it both? Are the areas divided? Are the areas overlapping? We have these kind of problems day in and day out. So if there are these kind of problems which arise in the working of the legislation, the courts will iron them out, and their overlapping powers are never by themselves criticized. As long as there is some way by which the authorities will work out for themselves as to when one authority will work and in what area the other authority will work. See, in India, we have to learn the art of working cohesively. We have a problem in India. Authorities tend to become insular, they tend to become turf-oriented. We have to learn the art of all working together, and we will get there, I'm sure.
Two last questions, Mr. Salvi. One, would you say, in sense, based on what you've read, this is a middle path approach between the free market US and the stringent EU norms, the GDPR as well? So, would you say, in some sense, a middle path has been drawn? Nandan Nilekani joined us a little while ago, and that was his assessment as well.
Honestly, I haven't studied the report in such granular detail so as to be able to say whether it has gone short of the GDPR, whether it is of the same level, whether it's a middle path. I think Justice Srikrishna is a great thinker, and he must have tried putting all these restrictions in an Indian context. Are we ready for imposing the kind of limits which Europe can with its financial strength, with its technological strength? We may not be ready for that degree of rigidity. Secondly, the governance in Europe is far more evolved is far more mature as compared to Indian governance. You've given too much for regulation in India and you'll kill the baby.
Fair point. Last question then, Mr. Salvi. The AP Shah committee report also on the issue of data privacy just died as a report. You know, we had Nandan Nilekani again lamenting the fact that he wrote on the need for a data privacy framework in 2010. A report happened and then nothing happened at the end of it. Are you more optimistic that the Srikrishna committee report will indeed become law and the lawmakers will you know, take it through the logical conclusion?
There is a commitment by the government to the Supreme Court. You know that young man who filed that petition in the court, which I had the privilege of appearing in twice, where the government has given a commitment that they are bringing a data protection law. And that is why the court has held back. So I'm sure now their government has to deliver on this. And I haven't read the report in full, but Justice Srikrishna is the kind of person who I would praise his report even without reading it. That's the kind of faith I have in him.
On that optimistic note, can't thank you enough, Mr. Salvi, for taking time out and joining us with your perspective on what really is a landmark moment for India as we set the framework for a data privacy law in this country. Completely timed out on this edition of the India Development Debate. News and updates continue on the other side. Up next is Top 10 at 10 with Tanya. Keep it with ET now. Good night.